Good afternoon, and thank you for joining me. My name is Rebecca Smith. I'm an attorney here in San Antonio, Texas. I have a practice located at the corner of 410 and Blanco. It's the Rebecca Smith Law Firm, PLLC. This information is true and accurate as of September 28th of 2022. As with all things legal, please make sure that you consult with competent counsel before making decisions about your business. And today's session is for informational purposes only. Please do not rely on it for specific legal advice. I want to talk a little bit about partnerships in Texas. On the slide, you see the state law definition of a partnership. It's just two or more individuals contributing money, labor, and/or skill to a business, sharing in its profit, losses, or management. As you can see, this is a very broad definition of what could be considered a partnership. And often this winds up in court being litigated, simply because the normal trappings of contract law are not here. There is no meeting of their minds. There is no understanding between the parties. There is no requirement for a writing. There can simply be a misunderstanding between individuals and one party mistakenly believe that they're in a partnership. And through the conduct of the parties, the courts have found that sometimes there is a partnership, even if one person was unaware of it. Because of this concept of joint and several liability, which means that if you are in a state law partnership, you are responsible for the conduct of the partner, right? Whether you know about his conduct or not, as long as it's within furtherance of the partnership. So what does that mean? Let's say you are working your evening, night, and weekend hustle. You think you got things going on, and your best friend since kindergarten offers to assist you with getting your business up and running. You think that they're doing it kind of as a friendship sort of thing, and in their minds, they're being a part of your business. So later, one of the friend, your best friend since kindergarten, has an opportunity to sign a contract on behalf of your business, and they sign it representing themselves to be a partner. If it's a true partnership, you are as liable for the actions of that partner as if you'd signed that contract yourself. Even though there was no discussion about whether or not someone was going to sign a contract, there were no information given to you as to the terms of that contract, there can simply be a misunderstanding between parties, and you can be held as liable for that contract as if you had signed it yourself. And when there's a breach and you get sued for the partnership, or under any circumstances, the partnership gets sued, everybody gets sued. That is the concept of joint and several liability. So an example with that contract, if the contract gets breached, even though you don't know about the contract and you didn't sign the contract, when the lawsuit happened, you very well could be included inside that lawsuit as a partner of a business as a form of joint and several liability. If you plan on going into business with anyone, whether it be your mom, your brother, your best friend since kindergarten, always make sure that you do that as at least a limited liability company to provide that separation between yourself and your business. Thank you so much for joining me this afternoon. I hope you found this information helpful.